Logan Paul may have just backed himself into a difficult position in his defamation case against Coffeezilla, and it's not because of anything Coffeezilla did, it's because of a legal maneuver Paul himself just made that could unintentionally benefit his opponent. Specifically, Paul filed a motion to compel discovery from Don Holland, who is not a party in the defamation suit, but is instead the class representative in the ongoing class action lawsuit regarding the Coffeezilla scam. Paul wants Holland to provide evidence ostensibly for use in the defamation suit against Coffeezilla, even though the evidence he's after appears much more relevant to the class action case. And at the same time, Coffeezilla is pushing to have the defamation case moved from San Antonio to Austin so both lawsuits can be overseen by the same judge, which would create judicial efficiency given the overlapping facts and parties involved. If Paul's legal team wants to keep the case in San Antonio and keep the lawsuits separate, they'll need to perform some fairly convoluted legal gymnastics, which may not go over well with the judge. Let's walk through what's happening here. Paul's team recently filed a motion asking the court to force Don Holland to produce certain documents and communications. There are 3 specific requests in dispute. Request number 1 seeks all non-privileged communications related to Coffeezilla, Logan Paul, or Paul's involvement in or promotion of Coffeezilla cryptocurrency tokens or NFTs. Request number 3 asks for all communications about Holland's purchases or sales or even consideration of purchases or sales of Coffeezilla-related crypto or NFTs. And request number 5 asks for Holland's communications about any cryptocurrency purchases unrelated to Coffeezilla. Now, from a legal standpoint, these requests are broad, arguably too broad. For instance, there's no time restriction specified, meaning Holland might technically be required to produce old text messages that have nothing to do with either case. If Holland badmouthed Paul years ago in private text, say, calling him immature for his infamous Japan incident, those technically could fall under request number 1, even though they have zero relevance to either lawsuit. Unsurprisingly, Holland has pushed back by filing an opposition to the motion. His main argument is that Paul's discovery requests are irrelevant to the defamation suit and are instead aimed at gathering evidence for the class action case, which is currently under a discovery stay. That stay means no party in that case is currently allowed to request evidence until certain preliminary issues are resolved. Holland's argument is that Paul is trying to circumvent that stay by using the defamation case to get information he's not allowed to access yet in the class action. That would be an abuse of legal process, using one lawsuit as a backdoor into another. And because Paul is seeking this discovery through the defamation case, he must demonstrate that it's relevant to that case alone. Personally, there is a legitimate argument to be made that much of what Paul seeks is indeed relevant to the defamation case, because the entire lawsuit hinges on whether Coffeezilla's statements calling Paul a scammer are false. Paul has to prove that he did not scam anyone. So, naturally, communications showing how the alleged scam affected investors or didn't could be highly relevant. But even if that's true, it's not up to Coffeezilla or Holland to admit that the court needs to hear that argument from Paul himself, which ironically helps Coffeezilla. Why? Because Coffeezilla has filed a motion to transfer the defamation case to Austin, where the class action case is already being heard. One of Coffeezilla's arguments is that Paul filed the defamation case not just to punish Coffeezilla for exposing him, but also to get around the discovery restrictions in the class action suit. He points out that both cases revolve around the same core issue: whether Logan Paul defrauded investors through the Coffeezilla project. Coffeezilla argues that because of this overlap, it makes sense for the same judge to manage both cases, even if they remain technically separate, to save everyone time and money and to avoid conflicting rulings. On Paul's side, however, his lawyers have insisted that the two cases are distinct and should not be combined or transferred. But now, Paul is about to argue to the court that the discovery he wants from Holland is directly relevant to the defamation case, a move that undermines his previous argument. Because if the evidence he's trying to get from the lead plaintiff in the class action lawsuit is important to the defamation case, then how are the two cases not overlapping? It's contradictory. This is where the concept of issue preclusion comes in. That's a legal doctrine saying that once a court has ruled on a specific issue in one case, that decision can be used in a second case, provided that for conditions are met, the judgment must be final, the same issue must appear in both cases, the issue must be essential to the original judgment, and the issue must have been actually litigated. If the class action trial results in a jury concluding that Logan Paul did scam investors, then Paul's defamation case could fall apart automatically because you can't prove a defamation claim if the allegedly defamatory statement that you're a scammer turns out to be true. This overlap makes the case for transferring venue much stronger. From the court's point of view, it makes sense to manage these overlapping cases together and possibly stay the defamation case until after the class action concludes. Otherwise, you risk to juries making inconsistent rulings on the same evidence. For now, Paul's legal team has put themselves in a tough position. They're trying to tell the judge that Holland's evidence is crucial to the defamation case, while simultaneously arguing that the defamation and class action lawsuits are separate enough that they shouldn't be handled together. That's a hard argument to sell without sounding inconsistent. And by pressing so aggressively for this discovery, Paul may have inadvertently strengthened Coffeezilla's claim that both cases are inextricably linked. If the judge agrees, we could see a major shift in how and where this case plays out. It's entirely possible the judge could decide to move the defamation case to Austin, or even stay it until the class action lawsuit plays out. Either way, Paul's legal strategy may have just made things more difficult for his side.